let's say you're kind of a cool Hollywood guy. You just got an 8-figure judgment. It's signed, sealed, and delivered, and you are ready to get paid. Time to warm up the deposit slip and get that money in the bank, right? Wrong. For that to happen quickly, you need the cooperation of the defendant. And in the case of Johnny Depp versus Amber Heard, it doesn't look like that cooperation is there. So we're going to look at what it takes to collect on a judgment and 3 ways that Amber Heard, and anyone else for that matter, can avoid paying the judgment. So the 3 ways we're going to look at, the first is common sense. The second 2 are going to have you dusting off your Shakespeare, looking up Henry VI, and taking another look at that passage about the first thing we do is kill all the lawyers and wonder, should that have been an instruction manual? So way number 1, be broke. Lawyers have a term for that, usually called judgment proof. If somebody doesn't have the money, you can't collect on the judgment. So just be broke and stay broke, or stay under the radar broke enough that there's no way that you have anything worth anybody coming to get. That's a time-honored tradition, applies to a lot of people in a lot of judgments. So having a judgment against you is bad. It can be on the books for 10 years, sometimes up to 20, depending on the circumstances. It's going to affect your credit, etc. But if you're happy being broke, then it's a good solution for you. Going to involve you spending a lot more time in TJ Maxx, potentially, than you had planned to if you considered yourself a Hollywood starlet. But there it is. That's way 1. Straightforward, right down the path. I don't have it, so you can't take it from me. The second way becomes a lot more complicated, and it can involve just a crafty defendant, or it can involve a lot of accountants, lawyers, and things like that. It depends on how much money is at stake and how much money the defendant wants to protect from the judgment. So if you secured your judgment in Virginia, as Johnny Depp did, great, you got it, there it is. If Amber Heard were sitting there with $10 million or more, then you're looking good to collect. And you can even get help from the state. Most states are going to have a function that allows law enforcement to help you collect, wage garnishment, seizing property, lots of things you can do to get your judgment collected. It's a very powerful tool if you can connect it to the defendant's assets. But that judgment is only good in Virginia, and Amber Heard probably doesn't have anything there. So now what have you got? You don't have much at this point. You've got to find out where she is and where her stuff is, and you've got to get that to her and connect it. So her job becomes, I don't want that to happen. I don't want you to connect with my money. I don't want your judgment to get anywhere close to the things that I own. So let's say she flies back to California and she has some things there. So then Depp's attorneys will go to California with the Virginia judgment and do what is called domesticating the judgment. Under the full faith and credit clause of the Constitution, states will respect each other's judgments in typical circumstances. So you file an application to have them recognize a sister state judgment, and then notice that they do allow the sister state judgment. I'll show the forms here. Once you do that and you wait, more waiting, there's always waiting in the legal system. It's worse than the military, maybe worse than DMV. After you wait and wait and wait, then your judgment is good there, and you can use the tools that California provides for judgment creditors to go get her stuff. You're in the game now. You're going to get it. You're going to find this money she has, nice house, furniture, whatever that you can collect on. Maybe not so easy. So there are lots of things that a defendant can do to shelter what they have. And one of those things is creating trust, putting the money in certain kinds of trust so that you can't touch them. There are ways to get around that if it was done after the judgment. California, not the best place to protect your money. There have been cases where sometimes the defendant will move out of California and buy real property, say in Texas, where they have much stronger homestead exemptions, put their money in that, and then when you chase that person to Texas, domesticate the judgment there, they will not let you collect on it because you're limited there. So the defendant's looking for strategies of, where can my money be that legally your judgment cannot come? There's a spell around it. You can't come inside of this circle. So that can be in the states that you happen to be in, but if it's not, go to another state that has the things that you need. Maybe it's Texas, where you can put your money in real estate. It could be another state that has stronger trust protections than the state that you're in does, or put it overseas in a foreign trust. Move yourself in addition to your stuff. Move around. Don't let the plaintiff know where you are. Go somewhere else and work somewhere else. And so now that person has to chase you around, domesticating the judgment, trying to find out where you're making your wages at, where maybe you put your money at. You're not volunteering to tell this person. And even if they're getting court orders for discovery and the like, just outrun that. So you keep this stuff on the move. You're hiding the ball. You're finding ways to protect the money. There are a lot of high net worth individuals who do a lot of this, of course, before they're sued. Say you're a doctor and you've accumulated a lot of assets, but you're in a high risk profession for getting sued. Your malpractice may not cover all of it. Then there are strategies you can execute to protect your money well ahead of time. And some of those are not available to be done after a judgment is given against you, but these people will pre-plan. But even in the case where it's after, you're still able to move yourself to another state and find the greater protections of each and every state. Some states have more limits than others on garnishment of wages. So if you're going to get paid for this next movie you're going to do, you want to go to a jurisdiction and live or earn the money in that jurisdiction so that you don't have your wages garnished like you might in another state. Maybe you'd even do it overseas, right? So there is a whole sub-practice of law dedicated to protecting your assets, either before you get a judgment against you or after that, and help you dodge collection on the things that you have, or at least minimize the impact of that. Way number 3, file bankruptcy. So maybe you don't want to live like a fugitive, always trying to hide your money or go from one jurisdiction to the next, or you can't find the right trust to protect what you have, and you owe more money than you're going to be able to pay. So you go to bankruptcy court and you just blow this whole thing up. Screw it, I'm going to file bankruptcy. Good solution? Well, the astute internet lawyer will say it is not, because bankruptcy does not allow the discharge of a judgment debt if it's based on willful and malicious injury to another person. So Amber, you're going to carry that judgment forward against you even if you do file bankruptcy. Got a disappointment for you here? It doesn't mean what you think it means. Willful and malicious. Now, it is true that in the Depp case, the jury came back with a finding of malice. But the bankruptcy definition of willful and malicious is not the same as most state courts' findings of malice. There's a higher level of mental intent required for bankruptcy discharge avoidance than there is to get a jury verdict at the state court. So sometimes people will try to get their jury instructions written in such a way that it would at least match the bankruptcy definition. But if you do that, you're kind of raising the bar against yourself, and plus the judge may not do it. So now what happens? If the person files bankruptcy and you're a judgment creditor, you're going to say, hey, they can't discharge this judge. We already litigated this. I have this judgment for defamation. There was malice in it. They can't discharge this. And it's already proven. We can't even argue about it anymore. It's an issue preclusion. It's stopped. It was already decided by a jury, so we can't even reopen it. It's been proven in a court of law. This was a malicious act, willful and malicious, so I get to keep my judgment even after bankruptcy against this person. But a lot of bankruptcy courts do not see it that way, and they impose this higher level of mental requirement. And guess what happens then? A trial. So if you want to keep your judgment, then you're going to have to introduce evidence at a trial showing that the defendant met this higher level of mental state than what was required to reach the verdict in the Virginia case. So they're substantially certain to cause injury. There are various words, I won't get into what it is. Just know that it's different and higher, and that means there would be another trial. So that means it is possible that if you file bankruptcy, that you could get rid of this $10 million judgment in a bankruptcy proceeding and have it behind you and look forward and enjoy shopping at TJ Maxx without always having to wait for a coupon or something. So that you've got better days ahead if you go through this bankruptcy proceeding and knock this verdict off. Point is, it's another trial to go through, though, and bankruptcy court isn't free for people to do. But it's the third option, kind of the nuclear option for big things like this, and I can't find another better way to deal with this. I'll just file bankruptcy. Long story short, you get your great judgment in court. You think it's time to collect. You've spent all this money on attorneys to get it. You just got more work ahead of you. You got to potentially chase this person around the country, chase and find out where their stuff is. And even if you do all those things, they may just head on down to the bankruptcy court and then you have to deal with it again. So the legal system can be frustrating in many, many ways. And this is one of them. There just often are not clean answers in civil cases. People in the criminal court when the trial's over, the person's either taken to jail in handcuffs or they let it free, and people are crying or they're laughing. But there's an end, right? Okay, the Law and Order, it's over. I don't know that there is a show for Law and Order Civil Division, because it would just go on like this, right? And you would get mad, you would break your TV, and you wouldn't want to watch it anymore. So the best litigation is no litigation. Stay out of court if you can. Johnny Depp was a special case here because he said he wanted to clear his name. I don't think he thought Amber was sitting on all this money that he might get a judgment for. But nevertheless, he has gotten that judgment, and people are curious, does she have to pay it? And the answer is she has a legal obligation to pay it, but she can avoid that with some strategies and potentially even get rid of the legal option if she goes into bankruptcy court. She's got an appeal happening right now, so I guess she's not trying these other options yet. But if he begins to collect on the judgment, or if the appeal's denied, we'll see what she does next. Or he may just not chase after this. We don't really know what's going to happen, but it's more complicated than first blush would ever have you think. And now you're educated on how the legal system is even more confusing and frustrating to everyone than you even imagined before. I'll let you get back to your Shakespeare. Thanks.